People versus Marquesi Hankey.
And then we have you, Your Honor.
Right out of the gate, this case tells you everything you need to know. Those jail call quotes you heard at the top, that's not bravado for the cameras. That's a defendant openly daring the court to stop him. And in a courtroom, especially during a bond hearing, that kind of attitude is basically handing the judge a reason to say no before the hearing even starts. Ask yourself, if someone won't follow orders outside of jail, why would a judge trust them inside the system?
All right, it's your motion.
There's a good probably in the case that previous PCC hearing, my client drove from privileges from the jail suspended due to allegations that he cut off his tether and contact with the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness, period, from the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond with tether. We know judge that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts from obviously people address this, that some of the language that was used in our conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contact the complainant even after his bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up the middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier refund that he was opposed to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So just I am asking the court to reinstate his bond. And if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he ever have had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had
he cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to.
This is a huge turning point. Cutting off a tether isn't a technical violation. It's a full-blown act of defiance. In legal terms, this destroys credibility. Bond is built on trust, and once that tether disappears, so does any argument that the defendant can follow court orders. From the judge's perspective, this isn't a mistake, it's a message, and it's not the one the defense wants to send.
Follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your mom gets revoked, you get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me.
This is the moment where the judge draws a hard line. The message is clear. Courts don't argue with defendants. They enforce consequences. The repeated calls, the stolen pins, the ignored restrictions, all of it adds up to one conclusion. So here's the real question for you watching. Was there anything the defense could have said at this point to undo weeks of defiance, or was this outcome sealed the moment those calls were made?
This is the kids say, mess around and find out. I guess that's not the quote, but it's close, but I did pretty good. I said it okay right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. First of all,